Good morning and a happy Sunday to all of you. And thanks for showing up for today's live stream. And of course, we have a very special guest that some of you may know already from the past. We've had him on a couple times before. Definitely a fan favorite. People like the way Solomon talks, likes that he's very blunt, says what's on his mind, says what he's thinking, and just moves from topic to topic with that in mind. So, no holding back, and that's what we're going to be hearing from him today. So before we bring him on, I do want to make a few mentions here. First of all, good morning to everybody in the chat. Thank you all for coming. I see everyone's wishing some good morning, so thank you. Thank you for Noreen living the dream, new member. Now you're going to be living the dream in the Brother Counsel side membership, so appreciate that. And also, I thought somebody said that it was their birthday in the chat, although I can't find it right now, and this would be like their birthday present, kind of. So I hope this is a good birthday present. I hope we're going to have a good show today. I do want to just let everybody know that Solomon is on the road, and he's out of his office. He's on the road. He's not going to be driving, but he is in his car because he was able to pull up where he's heading and just stop in order to do the show with us. So this is appreciate that for Solomon, even though he's on the road. And he's only going to have about an hour today. So we're going to try to get through some of the stuff. Obviously, we're going to try to recap quickly what happened the past week. There's a few big witnesses, Ian Whiff and Jennifer McCabe. I think most people want us to talk about Jennifer McCabe, so we'll talk about Jennifer McCabe. I want to show Solomon some clips from Jennifer McCabe's testimony. Some of them I spoke about. There's maybe one or two that I didn't speak about, and I'm definitely hearing his take on some of these clips during the cross-examination is going to be interesting to see what he has to say about them. So we're going to be spending probably most of the time on Jennifer McCabe, and we'll see what his take is. And obviously, if there are any questions, I'm going to try to get to the questions also. So put the questions in the chat, start putting them in there, and I'll do my best to get to them, maybe in the middle, maybe at the end of the show. But we're going to try to do whatever we can within an hour to cover as much ground as possible. So here we go. Let's bring on Solomon Radner. Solomon, you're in the car, but we appreciate you taking the time. And I know you got a crazy schedule last week, crazy schedule this week. And look, this is important, and people have been asking for your take, and they want to hear what your opinion is on some of this testimony. So thank you very much for coming on again.
Always happy to be here, and I guess thank you for pointing out that I'm not going to be doing this while I'm driving and that I actually pulled over. I guess it's important to point that out just in case anybody thinks I'm crazy enough to try this while I'm driving.
Yeah, that's actually funny because sometimes, when I zoom in on some of these court hearings a lot of them are via Zoom these days, and I may be in the car at some point, and I always right away mention to the judge that, Your Honor, I'm not driving. I just want to let you know I'm parked. So I'm just in my car while I'm doing the Zoom hearing. I'm sure you've had some of that also, right?
Yep, sure have.
Okay, so let's jump right into it. Before we jump into Jennifer McCabe, though, I want to talk about another issue, which I know we had a brief conversation about this on the phone. Excuse me. We had a brief conversation about this on the phone, and it relates to the ARCA experts, because one of the days this past week, it's also part of the recap, one of the days this past week was devoted, or one of the afternoons was devoted to the voir dire of the ARCA experts. Now, I know that you're somewhat familiar with the ARCA experts. I know that you know that these are experts that were hired really by the FBI to perform this accident reconstruction. And Hank Brennan's been arguing from the beginning that he doesn't have full discovery. He's not getting all the materials. He's not getting everything that's required under the Rule 14. And therefore, even if the defense did nothing wrong here, even if the defense did nothing wrong, because some of this material is protected, under this, it's confidential, it's protected, and they can't turn it over because of the federal government. But at the end of the day, he does not have full discovery, which puts him at a disadvantage. It does not allow his experts to get ready the same way that the ARCA experts are able to get the entire report, all the materials that the Commonwealth's expert had, and they're able to now use that to rebut Dr. Welcher, who's the Commonwealth's expert, and therefore it puts Hank Brennan at a disadvantage, and it's not fair. So this is the argument that he made to the judge. I think it was a compelling argument. Nevertheless, Judge Cannoni ruled that the ARCA experts can come in. Not only can they come in to testify about their original testing, but even to rebut the additional testing that they did to rebut Dr. Welcher's testimony. So what's your take about that? Some people on the side of the Commonwealth feel that, hey, this is not fair. Everybody on the other side screaming that Judge Cannone is biased. Well, look at this ruling. This ruling shows that it's not fair against the Commonwealth. So what do you have to say about that?
So I actually did watch the majority of this hearing, or at least the argument, from the lawyers and the ruling from the judge. And I thought the entire time that there was really no choice but to allow these witnesses to testify for one very simple reason. Let me just back up. If the judge did in fact find violations on the part of the attorney, it's very possible for the litigant to get punished for that. And I know you know what that means, but if you hire a lawyer and that lawyer does something that's against the rules, you can end up getting sanctioned. You could end up not being allowed to call witnesses. You could be not allowed to put on your case, and you could suffer in a number of different ways. What's different about a criminal defense case is that you have the constitutional right to effective assistance of counsel. And if your lawyer messes up and then you get convicted, you can go to the Court of Appeals and say, I was denied effective assistance of counsel. So in a case like this, if it's because of something that the attorney did, which is what it sounded like from the judge was saying, it sounded like she was saying there's all these repeated violations, and she has good reason to perhaps to sanction him, which she still may do. It's a very good chance, I think, that upon the conclusion of this case, she could issue a very serious sanction against Alan Jackson, if for no other reason because he won the case, perhaps. But there would certainly be a basis for her to do that based on these purported discovery violations. However, to preclude the witness from testifying, you're basically giving the defense a very strong issue for appeal if she gets convicted. So this kind of was the right ruling, and I'd like to applaud the judge for making the right ruling this time. We'll get into some of the other rulings that she made, but this one, she made the right ruling. That's all there is to it. There was no way around it.
Right. Okay. So even though it's technically perhaps unfair to the prosecution because they don't get all the materials, but still the right for the defendant to put on the defense is so high. And if the judge does not allow that, then there's going to be a very strong appealable issue of ineffective assistance of counsel. So she's either got to let it in or just set herself up for getting this all reversed anyway because of ineffective assistance. Is that what you're saying?
Exactly. That's exactly the point.
Okay. I do want to make one mention here, and I know that it's a question that I've seen already asked a number of times. I think people are talking about this online and on X, and I I kind of weighed in on it for a second, but let's see what you have to say about this. Okay, now, as you know, I'm just going to put the question up here because, as you know, there's a federal investigation going on. Now, very obviously, Judge Cannone is not, maybe I shouldn't say very obviously, but Judge Cannone is not allowing any sort of mention that there was a federal investigation going on, right? It's going to prejudice the jury too much. So no one's allowed to mention that there was a federal investigation. No one's allowed to mention that ARCA was hired by the FBI initially. That's all out. No one's allowed to say anything about that. So now what happened was Jennifer McCabe was on the stand, and Alan Jackson was being very careful not to mention which law enforcement agency was interviewing her at a certain point. Now, yes, she spoke to a lot of different policemen and a lot of different law enforcement, but at some point she was talking to a law enforcement agency that does not include Canton Police Department and Massachusetts State Police. Okay, so if the jury can't figure it out, then that's on them. But that's how he was required to ask the question. That's how he did ask the question. So he asked this question to Jennifer McCabe about being questioned by these investigators, and we'll get into more of the details later, I guess. May as well just bring it up now. But she got into this, what she told the investigators and what she did not tell the investigators. We'll get into the substance of what she left out in a minute, but I just want to bring this question out. So while she was being asked that, because she said on direct examination that she was always forthcoming, always was happy to speak to the police, never suspended any interviews, was happy to testify in the grand jury, was happy to testify in any sort of proceeding. She never was hiding from anything. And Alan Jackson got up there and said, well, there was those investigators that asked you questions and you suspended that interview. And she said, you're right, I initially did, but then I called them back and we had a full interview after I retained counsel. And then she looked at the jury and said, but that entire investigation is over now. So people want to know, that the way that she said that to the jury, she didn't say the FBI, she didn't say federal investigation, from what I remember. She said that investigation is over. And that's something that Hank Brennan reported in open court. So does that in itself, by turning to the jury and saying that investigation is over, is that opening the door for the defense now to be able to bring up that there was another investigation here and it was conducted by the FBI, they hired ARCA, etc.? Does that open the door for the defense to bring up that there was a federal investigation here?
Yes. See what I did there? How I answered your direct yes or no question with a yes. And I actually want to kind of tell you two things about that. The first thing is definitely it does open the door by her on her own offering. She wasn't answering a question. She knew what was going on. She knew what the rulings were, and she just decided to offer this. That investigation is over. You should be allowed to ask follow-up. What investigation? Investigation into what? How do you know it's over? Who's doing the investigating? Because she brought it up. Once a witness makes a statement, that statement can be tested on cross-examination.
Okay,
If
but
there's
now Alan
so
Jackson did not ask him this question. So now what about what? So you think recalling her, or you think bringing it up in some other
no,
context?
because he knows what the judge is going to rule. She already ruled. So he wasn't going to get into that. But I think that it definitely does open the door if Judge Canoni were going to be fair about this.
I mean,
Let's
he
back.
could have asked for a sidebar, you're saying, and said, hold on a second, we're not letting you off the witness stand just yet, and asked for a sidebar and said, Your Honor, she just opened the door. And then I'm able to cross-examine and make a ruling about it. But what about now that she's already off the stand? Can they bring it up in any other context now because she already put the issue in front of the jury? What do you think about that?
I would say yes. I would say it's been the door has been open, so to speak. However, and I'm sure Alan Jackson knows this, once there's a ruling on a topic, you don't bring it up until you go sidebar, and the judge tells you can do it. So if he wants to bring it in through a different witness, that's fine. That's great. But he better talk to the judge first and say, Your Honor, she opened the door when she made this statement. I want to be able to explore that statement now. I actually plan on recalling her on my case in chief and asking her about that statement. But by virtue of her saying that statement, the jury's got more questions than answers now. And if we could back up just a minute, I think Judge Canoni was dead wrong about this ruling. Because ordinarily, if the FBI is investigating, and by the way, I did have a case one time where my client was being accused he was being wrongfully accused. This is one of the most bothersome cases I've ever dealt with. And while I was dealing with these corrupt, dirty cops, I got phone calls from the FBI. They wanted to see my file. They started investigating these cops, and shortly after the trial, they ended up indicting a bunch of the cops. This goes back about 10 or 12 years. Okay, so when that was happening, obviously, I would not have been able to. You're being investigated by the FBI. That's a little bit, I don't think that would be appropriate. However, in this case, where the entire defense is corruption, the entire defense is cover up. The entire defense is the police intentionally covered this up. And now we've got her. Remember, there's that term that the prosecution loves using, consciousness of guilt. Look at how free she's being with information. She's telling her brother and her cousin and her uncle and her father and her mother and all these cops that she's related to and are good friends of hers. She's telling them all this information. She has nothing to hide. But the second there's another law enforcement agency where she has no control over them and no friends there, suddenly she starts lying to them. So absolutely, this would have been fair game in cross-examination. Why is it that suddenly when you're talking to the FBI, you're lying? Why is it that suddenly over a 10-minute period, you forgot how many phone calls you made? And I know we're kind of jumping the gun right now, but
yeah, well, that's going to bring us to the next topic. But
I think Judge Canoni was 100% wrong on this ruling. This should have been fair game under cross-examination based on the evidence that's already in, based on the evidence that's going to come in, and based on the theory of the defense.
Yeah, okay. Just to be fair, Judge Canoni did not make a ruling at that time, meaning Alan Jackson did not request a sidebar. I just wanted to make it clear. Okay, fine. So, but you believe that the door is open and therefore the federal investigation should be able to come in. The fact that she just forcefully turned to the jury and said something that was not an answer to a question, which is a pattern which we've seen from Jennifer McCabe, where she'll just answer questions that were not asked of her.
And we don't know if it's true. How do you know that's true, man?
Right.
She doesn't know that's true.
Exactly.
You don't get to just say things untested to a jury. The light was green. How do you know the light was green? Oh, no, you can't ask that.
Right, I got you. So let's talk about, okay, that's a perfect segue into the next question here about Jennifer McCabe, what happened with these federal investigations, investigators the first time, is that she was approached, and I believe it was in her driveway. She was asked if she's Jennifer McCabe by these two individuals, and she denied it because she thought that they were trying to sell her something.
Salesman. Yeah, sure.
So she's like, no, I'm Nicole or whatever. So she went to the house, and then she got a phone call from them saying, yeah, we're federal agents, or however they identified themselves. We need to come speak to you. She said, okay, I need 10 minutes. Okay, she needs 10 minutes. I don't know, brush her teeth or whatever, but so she needs 10 minutes. So
No, she
during
didn't.
those,
She didn't even brush her teeth. That's why she didn't know how to tell the truth, because she didn't even brush her teeth. And as you know, before you brush your teeth, you're not able to tell the truth. We all know that.
so, okay, so for those 10 minutes, she was she made a few phone calls. Now, the once she already got to once the investigators actually came into the house and they were talking to her, it was a brief interview. Okay, so when I think brief, I'm thinking under a half hour when somebody says brief, right? So 10-minute break, half hour. Now, during that half hour, they asked her, what did you do during those 10 minutes that you needed to get ready? Did you make any phone calls? And she said, yes, I called two people. I called Matt McCabe, my husband, for him to come home. And I also called, I think it was Carrie Roberts. I think those are. So then Alan Jackson explored why he calling Carrie Roberts, et cetera. Okay, he explored all that. Then it turns out, then they leave, and she calls them back and says, oh, I forgot to tell you that I also made some other phone calls. And she forgot to mention that she made 3 other people that she called. Peggy O'Keefe, I think it was Julie Albert, and then correct me if I'm wrong, I think it was Julie. And number 3, or I think it was Julie. Correct me in the chat if I'm wrong. Number 3 was Brian Albert. Okay, the homeowner of 34 Fairview. So Alan Jackson brings this out and say, hey, they told you that it's a lie. It's a crime to lie to them even in an interview. And they made that very clear. And then you call them back and you say, well, and she's like, well, I just forgot about it. She just forgot. She remembered the 2 people, but she forgot the 3 people. So what do you think about that? And what do you think the jury's thinking about that?
I think that, again, the judge ran interference for the prosecutor here, because one of the points that had to be made was why she made that
Oh,
phone
I'm
call.
sorry. Okay, wait, hold on. I want to correct this because Tiff corrected. Right, it was not Julie Albert. It was the DA's office. It was the victim's advocate. Thank you for correcting me. So the 3 people she called is Peggy O'Keefe, the witness advocate, and the victim's advocate, and then Brian Albert. Okay, so now we have that clear, and that's the 3 people that she forgot. So was that her forgetting, or does the jury saying, come on, you didn't forget 3 people and you remembered 2 people?
Well, okay, correct me if I'm wrong, but Mr. Jackson tried to bring out that the only reason we called the FBI is that she spoke to her husband, and her husband told her, you got to call the FBI back. And the judge didn't allow that because it's supposedly hearsay. Do I remember that correctly?
Well, I'm not sure. Some people say it's hearsay. Some people say it's spousal privilege.
Yeah, okay. Either way, it's absurdity. It's complete. Both of those make no sense as an objection. Okay. If you're talking to the FBI and saying something, or any law enforcement agency, and saying something that's not true, and then subsequently you call them back and correct the statement that you made to them, at that point, this almost becomes, you can almost invade the attorney-client privilege when something like this happens. Let's say you got a witness on the stand, you ask them something, and they say the light was red, and then an hour later you're cross-examining, and they say the light was green, and the only person they spoke to is your attorney. You could ask, did anybody tell you to say that? You can even say, and I've seen lawyers do this, and I've seen judges allow lawyers to do this. Did your attorney tell you to say that? Because if it's an instruction that has to do with what you're supposed to tell the judge or tell the jury, then that's not privileged. A lot of courts will allow it at the point, and I've seen that. I've actually seen, did your attorney tell you to say that?
So
So
if Matt
backing up
McCabe told
here,
her, so if Matt McCabe told her you can't lie to the feds and therefore you got to call them back, do you
right?
think that would be admissible?
Yes, 100% admissible. There's no question about it. It's not hearsay at all. And I know that most of the people watching this are probably not lawyers. Hearsay is not something that you heard from somebody else. That's not the definition of hearsay. Hearsay has a very specific definition. It has to do with being, it's a statement that you heard from somebody else being offered for the truth of the matter asserted. In other words, why did you go? Why did you push the gas? I pushed the gas because my passenger said the light is green. You're not saying the light is green. You're saying why you pushed the gas. If you say, why did you think the light was green? And you say, because my passenger told me it was. Well, now you're offering their statement for the truth. Now you're trying to pass along their statement as yours. But in this situation, if the only thing being conveyed is, hey, you got to call them back and tell them the truth, and then she does, that goes to her state of mind a heck of a lot more than anything she's trying to offer for the truth of the matter asserted. So it's absurd to not allow that. It's just absurd. And spousal privilege. Look, I'm not familiar with this particular. Every state has different spousal privilege, but uh, it's a stretch. It's really a stretch, especially if the thing that you're being told is don't lie to the FBI or don't lie to the agency. I thought it was funny that he kept saying agents. I don't think that was an accident. He kept saying agency. He kept saying agents. I'm sorry, Radner. I meant officers from this other law enforcement agency. So you told the agents, I mean the officers. I think he did that a number of times. I don't think it was an accident. But the answer to your question is I don't know what the jury's thinking because the judge may have successfully run interference successfully. And if she did in fact tell them, I called two people, and then 10 minutes later, without anybody talking to her, she said, "Oh, I'm sorry, guys, I made a mistake. I spoke to five people." Okay, that is a lot easier to accept than what really happened. And I think the jury heard enough to know that this was clearly fabrication. I think the jury heard that first she said there were two people, then they left. Then she spoke to her husband, and you can say all the objections you want, but she heard that the jury heard she spoke to her husband. Then she called them back. That coupled with the fact that it was only a 10-minute period, she called five people in a 10-minute period. That's frantically making phone calls. 10 people in a 5-minute period or five people in a 10-minute period, and you only remember two of them, it's absurd. It's an absurd claim. I really, really hope the jury doesn't believe it. It's
Yeah, see,
absurd on its face. It's
I
completely
was thinking,
incredible.
yeah, see, because I was thinking, you know what, like if first of all, she said it was a brief interview, like if it was a 3-hour interview, and then they asked you, okay, who do you speak to those 10 minutes? You just went through this ordeal, and you're like, oh, I called 10 different people, and you forgot to mention one. Oh, okay, like you got us 9, you
Right.
forgot one. I can understand it's a little bit more understandable here. You forgot more than you remembered. You forgot 3 people, you remember 2 people. Like it just doesn't sound so much like this is just a forgetful instance. It seems like there is, to borrow a term that Jennifer McCabe, a little bit more nefarious there. Okay, so, or nefarious, depending how you say it. Okay, so then we also had on the cross-examination, before we start playing the clips, I want to show you some of the clips here, but there's 2 other points of cross-examination that I just want to kind of talk with you about. One was the fact that there's a dog. And obviously we understand how important the dog is in this case, because if you look at the injuries to his arm, many people would tell you the common sense is that that's a dog. And I think you've said that to suggest to a jury that it's not a dog or an animal attack is offensive.
No, I said that if the two options in front of you are a dog or hit by a car, that's as offensive as trying to convince a NASA scientist to convince a jury that the Earth is flat.
Right.
And yes, it looking at those abrasions and those scrapes, if you tell a jury option A, dog, option B, hit by a car, and you try to bring in experts to say that it was option B, hit by a car, that is insulting on its face to the jury. Yes, I believe that.
Right. Okay. So now you know how important it is about this dog. So Jennifer McCabe's testimony was that there's all these lights going on. The lights, there's engines running, there's Karen Reed screaming outside on the top of her lungs, hysterical. The scene has been described as chaotic by a number of people. Carrie Roberts is screaming at Karen Reed to shut the F up. I mean, everyone's screaming around. There's lights. There's no sirens on, which Hank Brennan pointed out, which I think was a mistake because, like, I mean, come on, you're going to get slammed for that. But Jennifer McCabe tried to say, well, it was off to the side a little bit. So like you couldn't really tell. I mean, some of the excuses there just weren't going to work. So you got all these lights, all this thing. You own a dog, Solomon. I know that, So all this is going right outside the house. And then Jennifer McCabe comes into the house, which was described by some people as bursting into their room. And she doesn't have any sort of recollection about the dog at all. No dog barking. Dog wasn't around. She has no idea about where that dog was, what it was doing. And there's also some testimony that the dog was sleeps in the bedroom. So Alan Jackson pointed that out. Like, where in the world is the dog? With all this chaos going on, I think anybody that's a dog owner, you're a dog owner, would think that the dog would be going absolutely crazy at this point.
Um, okay, this I think comes down to you may not like my answer. I don't think the people watching this are going to like my answer on this. I think this really comes down to how accustomed to the dog the people are and how accustomed the people are to the dog. And I'll tell you what I mean by that. If there's something chaotic going on in my house, God forbid, and I run in and I'm trying to describe what happened, and I tell you that I ran here and I grabbed this and I did that and I came outside and whatever it might be. And then you ask me, where was Rex? Rex is my dog, obviously. I may not remember because it's not in my mind. Because I'm used to him barking, I'm used to him being there, I'm used to him running up and licking me, and it's for those of you who don't know, he's a little 12-pound mini poodle. All right, sweetest little thing. Definitely not a German Shepherd that's going to bite anybody. Um, but um, but if I'm describing what happened, I may very well forget it. And if you come to my house and let's say you come in and we have a beer together and get ready for a trial. And then I ask you what happened. You say, well, I walked in and your daughter was there and she asked me why you're here. And then we went and we sat in the living room and we pulled out the file and you pulled out your laptop and then I left. So, well, where was the dog? You may not remember also. I don't know how big of a deal it is at this point that Chloe's not accounted for. Now, the fact that um, Chloe may have been sleeping, I think a much bigger problem here is if the dog is sleeping in their bed, in their bedroom, and there's all this commotion going on outside, I can tell you right now, if there's a commotion going in front of my house, everybody in my house will wake up from Rex's barking. And I'd be very surprised if a German Shepherd, which there's apparently going to be testimony as an aggressive German Shepherd, has all this commotion going on in front of the house and at the side of the house. I'm I'm more I'm more bothered by the claim that somebody could sleep through that. Because at the very least, the dog would be barking like crazy and wake them up. But again,
Yeah.
that could possibly be offset by them being accustomed to the dog and not waking up by its barking. But I think they would wake up. I would wake up and my dog is barking in the middle of the night or in the early morning.
Yeah.
So
The testimony is going to be that they slept through everything. I mean, that's going
yeah,
to be the thing.
that's yeah, again, that's just I think that's a claim that doesn't make much sense. The only plausible explanation is they may have been completely drunk, which is possible. I know Karen Reed was drunk.
Okay. All right. So that was another point. And then one final point before we actually show you some of these clips, which I think you're going to find interesting. There was another point, and we brought on cross examination about the fact that she was looking out the window. Jennifer McCabe was looking out the window at 34 Fairview that night around 12 a.m., 12:15, 12:30, and she looked out a number of times. And there's some inconsistencies with how many times she looked out and whether she texted when she looked out. But one part which I thought was very interesting to me, which I think may have also struck a nerve with the jury, was she was looking out at one point. She was looking at the car, but she happened to have noticed that there was also tire tracks beyond the car, out of her peripheral vision. So that's what she noticed, and she wasn't even looking for the tire tracks. And she said, "Well, there's a light on over there." And then a couple minutes later, when she looked out of the house again, she looked. Sometimes she found the car, and at some point, the last time that she looked out, she did not see the car at all. Now, her line of vision was directly where John O'Keefe's body would have been laying if he was hit by Karen Reed's car. And she testified that she didn't see anything. So the way that Alan Jackson framed this is that, hold on a second. A couple minutes ago, you looked at the car without even anything, specific. Anything looked out of the ordinary to you, and you just happened to notice the tire tracks. Second later, you look directly where John O'Keefe's body would be laying, looked for the car. The car's not there. You probably looked around. Hey, where is that car? Looking around, and you don't notice John O'Keefe's body there. And according to the Commonwealth, his body was there.
Yeah.
So
this is one of those absurd claims which any reasonable jury will see right through. If the body was there, a lot more people would have seen it. A lot more people, not just her.
yeah, well,
So
we're going to get to
his
that
body
also.
wasn't there. His body just wasn't there. That's all there is to it. It's again, it's an incredulous claim to say that his body was there and everybody just somehow missed it.
Yeah. Okay. Well, this is the first one that we're hearing about. We're going to hear more about all the people that left that house did not see the body at any point at all when they were leaving. So we're going to see more about that as it goes on. Okay. So let me play for you something which I thought was very interesting, and also something I know you like to see. Different styles of lawyering, and I know that you have an affinity for cross-examination. I've seen you cross-examine many, many witnesses. So let's pull this up and give me your thoughts. I'm not even going to say anything. Just give me your thoughts about this the way that this is all set up and framed, actually, I got to go back a little bit. Okay, here we go.
Wasn't as important ingrained in my mind at that point. No.
And then
this is talking, just to give you a little bit of reference here. This is talking about the fact that when she was woken up by Karen Reed that morning, 4:53 in the morning, right? She was woken. This is her first time that she's being woken up by Karen Reed. And what she does is she makes 2 phone calls. This is where maybe I mixed up. So she made 2 phone calls. One of them was to Tom Beatty, and one of them was to Julie Albert. And she did not mention the fact that she made a phone call also to Nicole Albert, her sister, who lives at 34 Fairview. So she forgot to mention that, and that is what Alan Jackson is going to mention now. And just watch this back and forth for a little bit.
Testified at a grand jury, not hours or days later. Testified at the grand jury months later, correct?
Correct.
Oh, I'm sorry. Hold on a second. I'm not sure if that is the next part. Okay.
And at that grand jury, you also left out the fact that you contacted your sister, correct?
There's nothing nefarious. I remembered who I called. I didn't go back and look at phone records.
I didn't say it was nefarious. Why would you use the word nefarious?
Because there's nothing about me calling my sister that is nefarious, and I feel like you're insinuating it might be, and it's not.
Did you use that word because it sounds nefarious?
No, I just use the word because I think that's how you're trying to portray something that is nothing.
Or did you use that word because you think that's how it's coming across? That's nefarious.
No.
Without contacting them before fair.
No, not at all.
So what do you think about that back and forth? Why she forgot to tell the grand jury about calling Nicole Albert, and she offers, oh, there's nothing nefarious about that. And he says, hey, why'd you bring that up?
When you jump to your excuses before you even get the words out, it just doesn't sound right. It doesn't look like you're being truthful. And again, you and I have the advantage of having examined and cross-examined hundreds of witnesses at this point. You can kind of get the sense for when they're being truthful and when they're not. I watched a lot of her testimony, and she did a much better job this time. She stayed a lot calmer. She was less argumentative, generally speaking. And she did a much better job. But I do not think she came across as truthful. I think that her excuses don't make much sense. She keeps forgetting about people that she called. She forgot when she spoke to the FBI. She forgot when she spoke to the grand jury, and of course there's other things she forgot about when she spoke to the grand jury, which I'm sure we'll get to. But I think that by jumping up and saying, just offering when it's not even being asked of you, nothing nefarious. Yeah, you're kind of trying to get ahead of it because you know where he's going with it. Is that consciousness of guilt? I don't know. Hank Brennan would probably say so.
Right, exactly. And that's, but the fact that Alan Jackson right away picked up on it, it also, like I just pointed this out to people, people that aren't as prepared. This is what you see where trial lawyers have to think on their feet. You got your outline in front of you, what points you want to hit. But here it's like, wait, I just got something. I got a nugget, and I'm going to now use that for everything it's worth and not just move on to the next question. Okay, I got that point. She offers something and he just exploits it and shows to the jury how she's obviously trying to excuse something which looks nefarious. And I didn't even bring it up.
Right.
So like
that's how it looks. That's how it sounds.
Let's move on to the next clip that I want to show you. This is a clip that she was asked about whether she ever met with Michael Proctor and Elizabeth Proctor. Okay, Michael Proctor, as you're familiar with, is already the lead investigator in this case. And she met with him the next day. The next day, the day after this happened, she was called by him, spoke on the phone, and then he went over to her house. And they met. And they had some sort of interview, right? Then, September of 2023, she's meeting with Lieutenant Tully. And she's talking to Tully, and Tully asks her, did you ever meet with Michael and Elizabeth Proctor? And her answer to that, according to his report, what seems like, is that no, she never met with them. Now, let's see what Alan Jackson does here. It's going to be going on for a few minutes. And I want you to also pay close attention to the judge here. Okay? Because this may bring back some memories for some of your trials. So just take a look at the questioning. It's going to go on for a little bit. I'm going to have to forward a little bit of a sidebar, but just listen to the next couple minutes here.
With him, I just spoke with him.
Okay. In that interview with Trooper Tully, you were specifically asked about your relationship with Michael Proctor when Trooper Tully sat down with you in that, I think it was a September, or maybe it was an October interview, correct?
I don't remember the specifics of the interview.
He asked you specifically whether or not you had met Michael Proctor, whether or not you had any sort of relationship with Michael Proctor. Is that right?
I'm not sure the specifics of the interview.
Isn't it true that you told Lieutenant Tully that you had, quote, never met Trooper Proctor prior to September of 2023?
No, because Michael Proctor was in my house in January of 2022.
Exactly. The interview with Trooper Tully, I may have just a moment, Your Honor.
Okay.
The interview with Trooper Tully in that fall of 2023, where did that take place?
I don't recall.
Do you recall telling Trooper Tully that you had never met Elizabeth Proctor or Michael Proctor prior to September 2023?
No.
Would it refresh your recollection if you saw a copy of Lieutenant Tully's report?
I don't need to see the report because I know I told him that I met him on January 29th when he came to my house.
So again, Trooper Tully wrote that you never met Trooper Proctor before September 2023. That would be an error by him, correct? You have to ask for an instruction.
So
And I'm not sure if you heard what the question was. The question was, so if in Trooper Tully's report, he writes that you told him that you did not meet with Elizabeth or Michael Proctor from the beginning of the case through September 2023, that would be incorrect. Now, listen to what happens next. There's an objection, and now listen to the judge.
So again, that is sustained. Ladies and gentlemen, I instructed you on previous questions regarding the same type of thing, whether another witness is lying or not. Disregard the question and move on, Mr. Jackson.
So let me just stop it right there. What do you think
I don't
that
get what's wrong with that. I don't understand what's wrong with that question. Maybe if she would actually allow them to make objections and make normal rulings, I would know what was wrong with that. But no, I mean, I do that kind of stuff all the time. A lot of my cases have police reports. You can't introduce them as substantive evidence. You can use them to refresh recollection or to impeach. Now, obviously, she was very well prepared, and that's very clear that she was very well prepared for this. And I'm guessing that one of her instructions that she received from whoever prepared her was, if Jackson ever says to you, would it refresh your recollection if you saw A, B, and C, to just say no, it wouldn't. But the thing
and
is,
she
you still
does
get
that
to show it to her. You
she
still
does
get to
it
show it to
routinely.
her. Right, right, but you still get to show it to her. If I say, would it refresh your recollection if you saw the report? No. Well, let me show it to you. Maybe it will refresh your recollection. I'm allowed to show it to you. And then say, look at lines 7 through 11, where it refers to your statement. Does that refresh your recollection? And obviously, she'll still say no, because it appears that those are her instructions. But then for impeachment purposes, and that's obviously a separate court rule, you should be allowed to introduce it to impeach her. But regardless, if there's going to be testimony to this effect, whether from that officer or from somebody else, and I'm assuming that the officers in this case who took the report will ultimately testify, then one of the questions is going to be, did Jen McCabe tell you this? Why did you write this in your report? And then it will come in, because then there's a foundation for it. It's not hearsay. So you can use it, but now you can't impeach her with it unless you recall her. Once it's an admitted exhibit through that officer, I guess the defense could recall Jen McCabe as a witness. And let's say, okay, now that this is an admitted exhibit, now take a look at this report. And that may be what Alan Jackson's going to do. And I think that would be a very, very strong point.
Yeah, but I mean, this is what happens a lot of times with this. We're noticing is that there'll be something different in the report.
Yeah,
there's something different in the report that
Right.
and then she's testifying to now. He's using it to impeach her. And part of the questions is, okay, so if that is in a report somewhere, that report is wrong, right? Or that was the police officer made a mistake, and she doesn't allow those type of questions.
The way that I would frame it, and this is really semantics, but because ultimately you're allowed to have witness testimony come in, and this document may or may not, the way I would phrase it is, if Trooper so-and-so were to say that you said this, would you dispute that? If Trooper so-and-so were to testify that you said this or didn't say that, would you dispute that? Now, I don't know, the Judge Canoni probably wouldn't allow that either, but I think that's a little bit of a more buttoned up way to ask that question. And I think that you really have to allow her to answer. You're not asking her to say whether somebody else is truthful or not. You're just simply saying, if John were to say the light was red, would you dispute it and say the light was green?
Right. I
Simple
get
as
that.
that.
I get
So
that. And
that's the way I
also,
would phrase it, but I don't think it would make a difference with this judge. I think she's made her mind about not letting this in.
yeah, and I think also part of it is that even if you want to say, okay, you cannot testify that another witness is being untruthful, okay, that's fine.
Right.
But to say whether a report is accurate or not, I'm not saying that the person's truthful or not. I want to know if this report is accurate. So,
Right, but well, that's why I would phrase it differently. It makes the same point, but it's a little tighter. It's a little more buttoned up based on the rules. But either way, it should be allowed in. It's cross-examination. There's nothing wrong with it.
okay, so now
It's her statement.
listen to the rest of what happens here, because also when I was watching this, I went on a little bit of a rant. But let's see what you think about it. So let's continue for a little bit.
If you had told Trooper Tully, Lieutenant Tully, that you had never met Trooper Proctor before September of 2023, would that have been a truthful or an untruthful statement?
Exactly like these.
Okay.
Did you hear that question?
Yeah.
Anything wrong with that question?
None, not at all. Was that not allowed? I couldn't hear.
Yeah, it was not allowed.
Well, that's Canoni being
If
Canoni.
you
That's
if
outrageous.
if you would have told Trooper Tully that you did not meet Elizabeth or Michael Proctor until September 2023 or whatever, would that have been a truthful statement?
Right.
That was the question.
Right. Right.
Anything wrong with
there's
it?
absolutely nothing wrong with that at all. It should have been allowed. I can't even think of a reason. What is it? Speculative? I can't even think of a rationale to not allow that question. If you had asked Judge Canoni what the basis was for sustaining the objection, I don't know if she'd be able to say the answer.
Okay, well, listen to this.
Speculative? I mean, is that what they're going to say, that it was speculative? It's not speculative.
I mean, you're not asking her to speculate about.
You're not asking to
About
speculate
some-
about anything. It's a
You just wanna
completely
know-
legitimate question. It should have been allowed. There's no question about it.
Okay, so now let's forward ahead a little bit
Come
more
to
because
sidebar, please.
now they're going to have a sidebar. Okay, so I'm going to forward the sidebar and then watch what happens after the sidebar, because this is also where I'm not going to say anything. Let me just see what your take on the next back and forth is.
Another admonishment.
Okay, so
about
this is
Jackson in
after.
front of the
So this
jury.
is okay. So this is after the sidebar. Okay, and now let's do this. Let's see what happens.
Next question.
May I? Did you tell Trooper Tully, quote, you had never met Elizabeth Proctor or Michael Proctor prior to September 2023, end quote?
I had never met Elizabeth
That's not my
Proctor
question.
prior. Well, there was a,
Did you tell Trooper Tully, Lieutenant Tully, that quote?
if I can break that quote up because it's two thick parts.
No, you can't.
So
My
this has been
question is my
asked and answered. Move on, Mr. Jackson.
Do you deny?
Did you see what happened there?
Yeah, the judge is running interference for the prosecutor again. This judge should be ashamed of herself. She really should.
I mean, there was no objection there by the prosecutor. She just interjected herself, saying that was asked
No, but
and
judges
answered.
are
Now-
allowed to do that, and judges do that sometimes. If somebody does something that's clearly improper, judges will interject. This is not one of those situations. That there was nothing wrong with that question at all.
but not
And
only that,
it
but
wasn't asked and answered. She said, "Well, I got to break it up." And then when he said, "No, you can't break it up," then the judge goes, "Asked and answered." What are you talking about? He was about to answer it. She was about to explain. Let her explain. Let her answer the question. Let Alan Jackson break up the question. But to say that she's about to answer the question, Alan Jackson says, "No, I want you to answer it the way I asked it." And then the judge goes, "Asked and answered, move on." No, it wasn't. What are you talking about?
exactly. I don't think the question was answered either. She just said, "Well, I know I didn't. I know I didn't. I know that I did meet with Proctor before." That wasn't the question whether you met with him. The question was,
Right.
did you tell that?
Did you tell that?
Tully?
Right.
So, okay. So there, again, that was just also when I was watching this, I was a little not so happy with that back and forth. Okay, let's move on to one other clip here, and this is where he's asking her about near the end of the cross-examination, where he's asking her about when she arrived at the scene and she sees John O'Keefe there lying, either dying or dead. and she knows that she has her brother-in-law in the house who's a first responder. And let's think about the scene for a second. You got three little petite women there trying to figure out how to do CPR. Okay, now maybe some of them have taken, some classes on how to do CPR, maybe 10 years ago, whatever it is. But they are three women that probably are not as strong as Brian Albert, a Boston cop, right? And you've seen him before. He's a big guy. So Alan Jackson's point here was, why wouldn't you go get Brian Albert? This is your brother-in-law. So let's see look how he sets this up. And you can tell me your thoughts.
McCabe, on all of Fairview, the entire road between Chapman and Cedar Crest, can you think of any person on that road who might have had life-saving techniques trained into them? First responder, someone who knew how to deal with someone in distress, someone with high skill level training. Do you think of anyone on Fairview who had that kind of training?
Can I now, or did I then? Which are you asking?
Did you then?
No, then my focus was on John O'Keefe.
Okay, let me narrow the focus. How about on the property? How about at 34 Fairview? Could you think of anyone that was a first responder who would have life-saving training, life-saving technique training under his belt?
Yes, my brother-in-law, Brian Albert.
And you didn't go in the house, did you?
No, I did not.
When you arrived at the scene, you didn't go in? Not until much later, correct?
Our focus was John.
You knew that Brian Albert was inside the house. You'd just been with him hours earlier, correct?
Yes.
You knew that his window was 30 feet away. You're staring at it. You could look at it if you wanted to, correct?
It's off to an angle.
And you didn't go in the house then either.
I did not know.
You knew that John O'Keefe was clinging to life during those precious minutes and seconds. Is that right?
I did, yes.
And you also knew that Brian Albert, your brother-in-law, was a first responder trained to deal with people in that kind of distress, correct?
In that moment, my only thoughts were John and everything we could do for John.
And you knew that there were warm blankets inside the house. Is that right?
I did, yes. There were warm blankets in the house.
And you
Those
still
weren't-
never went in, did you?
No, I went and attended to John because once I finished calling 911, I went over to John and Kerry Roberts asked me to take over compressions. So I felt like that was more important and 911 was on the way. I never thought about going in the house. I just thought, how can I help John?
You never thought about going in the house, but you did pull out your cell phone and make 2 phone calls, didn't you?
After I called 911, I tried calling my sister, yes.
While John was out in the cold, clinging to life, you weren't doing chest compressions at 6:07 and 6:08, were you?
I was walking over when I was calling.
You were calling your sister on the phone, weren't you?
I was calling them to see if they would come out, but I was going right over to work on him.
And you could have walked 25 feet to the front door, walked in the house, and screamed for Brian Albert to come out and help you in those precious seconds and minutes, couldn't you?
That would have taken me away from helping John, getting Harry blankets, giving him compressions.
And making those 2 very important phone calls at 6:07 and 6:08 that you say were not answered. Correct?
They were not important phone calls. I tried to call my sister, and then I focused on John.
I thought that was so interesting. They were not important phone calls. She's saying how her only focus is on saving John.
She's too focused to go get her brother who's CPR certified, and she didn't want to take away those few seconds to go get him, but she was willing to make 2 phone calls that were not important. Okay, again, it boggles the mind. If there's any juror who would believe this nonsense, I would really question them. I really, really would. First of all, these scenes are very chaotic, and I don't know if your viewers know this. I know that you know this. I'm a volunteer EMT. I'm on scenes where we do CPR, and I'm on first response type scenes. They're chaotic, they're loud, they're scary. Not only do they often involve and are people watching anybody who's in front of the house that we're at, but very often people come out from other homes because they see the flashing lights, they hear the noises, there's a commotion, there's clearly a commotion going on, and neighbors will come out and try to figure out what's going on. I don't really like when they do that, but they do that. So the fact of the matter is, if unless of course they know he's dead already, if they're actually trying to save his life and her number one priority is saving his life, then she would go inside and get her brother-in-law. It boggles the mind that she wouldn't. And the argument or her claim that she was too busy focused on John, okay, that's a good argument. That makes sense. But if she's going to go and make phone calls, why wouldn't she yell for John or yell for her brother-in-law, or at least yell, scream, make noise? Hey, wake up, come outside. Even if you're not going to run to the door and bang on the door a few times. Now, I will tell you something else. You said, 3 petite little women doing CPR. I will tell you that I've done CPR with petite little women and with big guys. It's definitely draining, but women can do CPR just as well as anybody. All right. It's very draining, but I'll tell you right now, the first time I did CPR, I didn't make it a minute and a half. About a minute and a half, 2 minutes in, I had to take over. I had somebody take over for me. It is exhausting. It's very exhausting when you're doing compressions. And it's not easy. You gotta go down, you gotta come up, and you gotta keep going. You gotta go fast. So it's not easy to do. It's very exhausting. You want more people there. Different agencies have different rules for how many people have to be there by CPR call. Generally, it's at least 4 or 5 because you need to cycle through responders to do CPR and to do the compressions. So if there's
Right. So
another person trained to do it inside, it makes no sense that you wouldn't run in and get him. Just like if there was an AED in there, it wouldn't make sense that you wouldn't run in to go and get that either. You would have to.
right, and part of it also is that there's three women there. Only 2 of them possibly are doing CPR. So as soon as, let's say, she's taking over for Carrie Roberts, why not send Carrie Roberts to go into the
Right.
house?
That's what I can tell you right now. If I were on scene and there were 3 people doing CPR, obviously I probably have more training than they do in this respect. But if I'm doing CPR and there's 3 people doing it and there's a 4th person 50 feet away, then what we would do is we would continue doing it just 2 people and then send somebody in, just go run in and grab somebody. And then that way at least go yell at the door, bang on the door. Bang on the door, and if it's somebody I know, if it's a family member or a friend, I'd probably kick that door in. But I mean, if the door's open, obviously it's easy. Just open the door and
Yeah, it was
just yell,
unlocked.
"Hey, get down here, and then you come back and you keep doing CPR. But yeah, to not even try to get him for the CPR, really, again, it just boggles the mind. It really does.
Right. And I think it really when she said that she made 2 unimportant phone calls.
Right.
How how much were you so concerned about John O'Keefe when you're making 2 unimportant phone calls?
Right.
Okay, let's get to a question here because we're running out of time. Here's a question from Alexa. In trial 1, 9 out of 12 jurors voted guilty of OUI manslaughter because Karen, number 1, was drunk. Number 2, drove with John. Number 3 was charged. Defense's evidence was deemed a distraction. How would you argue in trial to counter that rationale?
My focus would be on reasonable doubt. That's what my focus would be on. There's aspects of this claim where I think Alan is proving actual innocence, and there are elements of the claim where I think he's going to be able to prove reasonable doubt. But I think there's definitely reasonable doubt as to whether she hit him. Now, if she's charged with drunk driving, she'll be convicted of that. There's no question about it. But if she is charged with manslaughter, with OUI manslaughter, I don't think there's any proof beyond a reasonable doubt at this point that her car made contact with him and
Right.
caused him to die. I just don't see how you get there. If 9 and 12 jurors were there before, that's very surprising to me. I'm frankly very bothered by that. But all I can tell you is based on the evidence that I'm watching now, and obviously I didn't watch the first trial. But there's just nothing. Like that expert didn't really help them. The cell phone expert, in my opinion, just created more
Yeah.
doubt.
Yeah, well, the cell phone expert also is not really talking anything about the car. I mean, ultimately, it all comes down
Right.
to whether
No,
this
I
car
know.
made any sort of interaction with John O'Keefe, which is what you have to focus on. I mean, like that's
Well, what
the
it really
main.
comes down to is there a doubt that you can attach a reason to? And there's lots of doubt that you can attach lots of reasons to.
Yeah. So I think let's put up another question here from Lucid Visionary Girl 88. What if John found out about Karen and Higgins in the car? He left car mad, threw glass. She now thinks he's cheating to get back at her when he didn't answer. And he went in the house and swung at Higgins and the dog jumped in. Okay, well,
Okay.
I mean,
Okay, this is a murder trial. Maybe helps the defense a lot. The more question marks there are, the more the defense is helped. So all that is possible, but the fact of the matter is, the prosecutor has to prove beyond a reasonable doubt what happened here. And I don't see how he can possibly do it with the evidence that's available.
yeah. I mean, and we
In
haven't
fact, the
even.
longer this trial drags on, the more I think he's proving her innocence.
Yeah.
Like
Here's a
those text
question.
messages. Goodness gracious, those text messages.
Oh yeah, talk about the
Unbelievable.
group text because I know that the group text is something that you like mentioned something to me. What did you think about the group text? Is this just a family talking together through this horror and trauma that they went through, and just, in touch with each other because they all went through this trauma? Or is there something a little bit more that it looks like is going on?
You tell me. You have family chats.
Well,
We're on
Solomon,
some of them together. It's
we want
absurd.
to.
It is an absurd claim. It's an absurd claim. It makes no sense. They're literally discussing the case. They're literally listening to each other make statements. Wow, she can write a book. Are you kidding me? And the fact that the prosecutor didn't bring these messages out first, I think is a real problem. A real problem. Because I'll tell you what happened. When a witness testified under direct exam, and then suddenly you're being crossed, it's always a question of, okay, what's going to happen here? What are you going to get out of this witness? When there's a new bombshell that's dropped, the first thing you wonder is, holy cow, what's the answer? The second thing you wonder is, why did the other lawyer bring that up? So all those messages really do not look good for the prosecution. I don't see how they explain away these messages. The messages alone create tremendous reasonable doubt. I mean, when you read those messages, you could certainly conclude that they were colluding with each other.
Yeah.
All there
Okay.
is
Well,
to it.
that's definitely how a lot of people are looking at those text messages, and some people are just arguing, well, this is just a family who's trying to figure everything out and trying to, just, deal with it as it comes along, and just talking with each other. So, I mean, but
And
yeah,
listen
I
to
mean, your
people make
point.
stories. And by the way, that's also why the FBI should be allowed.
Yeah. So you
The
really think
fact
the
that it's the
FBI should come
FBI.
in?
So
Yeah.
100%. The fact that it's the FBI, 100%.
Here's a comment or a question by Matthew Bradford. Did other neighbors come out due to the commotion? Well, Jennifer McCabe testified that no neighbors came out due to the commotion outside. And some of the argument that was that in 32 Fairview, nobody came out at that point. I thought that there may have been some dispute about this, but that was Jennifer McCabe's testimony, that nobody else came out that morning. So it wasn't just 34 Fairview, but any other house, even across the street or anything else. So
I saw an interview with a neighbor on the news.
Oh yeah, that was going around.
That guy, the middle-aged to old guy who just completely, threw a torpedo at the prosecution's case in like 30 seconds. Their cell phones all disappear, the dog disappears, the home disappears. Come on. The buddy's not there. Come on. He summed up the entire case in 30 seconds.
Yeah. It's funny because I was thinking about this. The reason why Jennifer McCabe testified was really, the point of her testimony was to say that she said, I hit him. I mean, that was really the crux of what they needed her to testify about. But of course, that took a day and a half, and she also had to talk about not doing the Google search. Okay. Here's another a question, from Helen Lewis, who's a big supporter of the channel. Appreciate Helen. Brother Solomon, what is your opinion about why the prosecutor decided to try this case and double down? Why do you thinking given all what are they thinking given all the doubt?
Okay. You're not going to like my answer. Your viewers are not going to like my answer. The DA, well, let's separate two things. There's the DA and then there's Hank Brennan. Okay. Hank Brennan, I would like to really believes she's guilty. I don't want to believe otherwise. If you're going to take off from your private practice and be a special prosecutor and try a case for months at a time, I would sincerely hope that you're not just doing it for the money or for the notoriety or for the fame. I would sincerely hope that you're doing it because you think she's guilty. And I think he does think that. Okay. Now, how does he think that? Even though what I think there's obvious evidence that proves she's innocent, sometimes you can get stuck with tunnel vision. Sometimes you could just see things a different way. I mean, you and I have both tried cases where an attorney is making an argument to the judge or to the jury, and everybody's kind of looking at each other like, is this guy serious? Who's going to buy this? But at the same time, you kind of convince yourself, right? You see things with tunnel vision, with horse blinders, that you only see things one way. And then, maybe that's all you can see. Now, the actual DA, we've talked about him before. We've talked about that ridiculous statement that he made to the news. But what his motives are and what Hank Brennan motives are, I'd like to think are different.
Okay. Here's another comment or question. I know we have to wrap it up soon, so we're trying to get through these last few super chats. No Shrinking Violet says, remember trial 1, Karen's phone caught Jen whispered a call to her sister, are you going to come out and help me? and that was from Microdots. So again, we haven't really heard that in this trial. We haven't heard it being argued in the first trial, I don't think. If there was, I think that if there'd be this audio, it would somehow come out in cross-examination with Jennifer McCabe. So we do get a lot of information on this case where we don't always see it come out in trial. And I try to focus really on what comes out during trial. So I know Turtle Boy's got a whole bunch of information that, doesn't come out in trial eventually, and maybe Microdots also, but I try to contain this channel to only what's going on during trial. So if that is brought up during trial, it'll be very interesting to see, and we'll talk about it then. But right now, I don't want to speculate about it.
Mm-hmm.
Here's the Ghost of Brian Higgins SIM card. They were not figuring things out. They had a game to get to. Oh, so that was in the group chat where they said they're going to miss the basketball game.
Right.
Okay.
Again, it goes to show the callous. I mean, I don't know. I think it shows some callousness. It shows some unseriousness.
Yeah, exactly. I mean, like, who's thinking about
Those
a basketball
messages
game?
are bad. Those messages are really, really bad. Really
They're like
bad.
thinking about the
For the
basketball game.
prosecution.
Right, exactly. Okay. Clara Ford said, who the heck holds Bev accountable, meaning we're Judge Cannoni. So we've spoken about this a number of times, Solomon. You've said that you can make complaints, and these are the courts are for, but ultimately when you try to complain against the judge, usually nothing really happens in it.
Yep.
So
999 out of 1,000 times. And I have to say that because it's way more than 99 out of 100. If you complain about a judge, you're going to lose. That's all there is to it.
Exactly. Here's another one from Melinda Kirk. If Carrie followed Jen and Karen back to JOK's house before driving to Fairview that morning, how did she not notice her broken taillight if she had hit him? So,
Good point.
Carrie followed them back, and then, she was paying attention to the road. I'm sure we'll hear the same kind of excuse. It was covered up with a lot of snow, and eventually she did recognize it. She did see the broken taillight. So, I'm sure we'll hear a lot of more of the same. So, look, I mean, they both testified that they saw the broken taillight. It's just a coincidence that that ring camera is missing, where it would have shown that she was shown that. It's also a coincidence that this statement that Jennifer McCabe heard Karen Reed say that was so impactful, was so memorable, was something that she would never forget, just doesn't appear in any police report and doesn't appear in her grand jury testimony.
Right, despite 12 quotes. 12 statements attributed to what Karen Reed supposedly said, and not a single one of them is, I hit him. It's just, did I hit him? Could I have hit him? And she probably was saying that. She was very drunk when it happened, and they had her. I think they tricked her successfully. At first, she got there, she was still drunk, she's looking around, and she's like, oh my God, did I hit him? And then it's not until later that she realized, oh my God, no, I didn't. But yeah, at the time, the first thing you wonder yourself is, did I do it? That's a perfectly normal and reasonable human reaction.
Yeah, most likely at the time that she arrived at the scene was like 6 o'clock in the morning. She was probably still technically over the legal limit. Because
based on what I saw, it sounds like she definitely was.
Yeah. Okay. Here's another question again. Kelly PCG: can Judge Cannoni lose her job after this debacle? Again, Solomon's opinion is that nothing like that's going to happen. Okay. Next question from Logic and Reason: should the defense file a motion for a required finding of not guilty on the murder charge once the Commonwealth rests, even though Bev will deny
the answer to that?
The answer is that
we both know the answer to that.
They're going to argue it. They'll just like they did in the first trial, but Judge Cannoni is going to deny it. So yes, they will do that, but nothing's going to become of it.
It's called a motion for directed verdict, and it's the defense asks for one in virtually every single case that I've ever seen. The defense always does.
Yeah, I mean, I've seen cases where you'll just get up, you won't even argue, just because you have to preserve it. So you'll just say, "Motion for directed verdict, Your Honor," and we'll okay, denied. Move on.
Right.
That's the end of that. Okay, fine. So Solomon, we already went over the hour. It's an hour and 3 minutes. I know you're busy. It was great having you on again. Hopefully we'll be able to do this again, hopefully soon. Again, I don't want to lock you in on every Sunday now because, I know that your schedule is unpredictable, and right now you're in Pennsylvania. So, but we appreciate always having you on. Thanks again, and good luck with everything that you're doing today and this week.
Thank you. I always appreciate being here with you. Have a good one, everybody. Happy Sunday.
Thank you. All right, everybody. So that was Counsel's brother Counsel, Solomon Radner, giving his takes on the case. And it's always interesting to hear. He's very blunt, says what his opinion is. And that's what it is. So thank you all for joining. There will be, of course, trial starting tomorrow, 9 a.m. We will be live streaming it from right here, Brother Counsel Studios. We'll still continue to try to do the recaps. And we'll, we're watching this case. We're following this case as much as we can. Just makes my weekends a little bit more crazy because I got to catch up on work. And during those breaks, we got to catch up on it. Looks like there was another question there before we leave. Where was that question that I just saw? Someone said one more question. Here it is. Tina Lucille, quick question. Did anyone hear Jen McCabe say to the 911 that she found a man in the snow? As opposed to just everyone was focusing on that she saw that there was a man in the snow, as opposed to she saw a man in the snow. She found not the 911 call was not so clear to me. It was very hard for me to hear. So I don't know if somebody else picked that up. I didn't pick it up, but that's what it is. Okay. Here's another. Thank you for having such a great chat and open minds and respectfully disagreeing. And this was great. Well, good. That's one of the things that we like to do. We like to have debate. And if we can respectfully disagree, that's part of what I agree. That's why I offered other lawyers who disagree with me after last trial to come on and discuss it with me. I eventually did speak about it with Kevin and Kate. They took me up on it. Nobody else did. Maybe this time will be different. Maybe I'll get some other lawyer who will disagree with my take on the case, and we'll have a nice debate. I mean, that's what this is all about. It's not just about talking to an echo chamber. I'm trying to be as objective as I can about this case, trying to keep an open mind. And if some lawyer out there can disagree with me and convince me otherwise, then of anything, then I'm always open to hear. I'm always open to reevaluate my opinions. So great that we're having a good chatter. I know we always have a good chatter. Here's a question that it keeps coming up. Honey Bunny, what do you think of Judge Cannoni and Commonwealth Brennan not verbal communications in voir dire? I know people are making a big deal about this, and again, I'm telling you that some of this is when you're wearing certain glasses, everything looks that way. When you're wearing, let's call it purple glasses, everything looks purple. So when you think that there's something going on with the prosecutor and the judge, you think the judge is biased or this and that other thing, then you'll read a lot into these type of things. I've had cases where I have a witness on the stand, and I'll look at the judge and I'll give a face like almost like Hank Brennan did. And people can read a lot of the stuff into it. I'd caution you about that. Let's really what I try to focus on here is legal analysis, which it's more limited to the cross-examination, more to the evidence, more to the facts. I know that other people try to read into a lot of other things that are going on in trial. We try to keep it here much more factual, much more evidence-based. And what I can tell you is that I've done that before. And I had nothing doing with the judge. It's just I got frustrated with a witness, and I'll look at the judge, like just shake my head or just some sort of facial expression. And because sometimes, like Solomon says, like people in the courtroom would all be on the same team, like this witness is not being honest or whatever. I mean, I've had moments like that. So I would caution you, about reading too much into all the nonverbal stuff and anything else going on. So just be careful out there. I know that there's a lot of talk about every little detail in this case, and therefore people are saying all types of things. That's why on this channel we keep it very factual. We keep it very evidence-based. We keep it on what the witness actually said, what the cross-examination looked like. That's how we try to keep it on this channel. So that's what we do. That's why we're here. And it looks like that's going to be it for today. We'll see you all tomorrow here for the live stream. And then, of course, keep up to date with Brother Counsel, because we are covering this case like we've never covered any case before. So obviously a very important case that we have to keep our eyes on. I think all lawyers should be concentrating on this case, and anyone who has an opinion or can offer some insight should be looking at this case and offering it. I know how toxic it is out there. Believe me, I know. I've gotten it from plenty of people, because in this case, it's almost like you can't say anything without people coming after you. But look, this is an important case, and a lot of people are looking at it. And if you have some expertise to add to it, you should. That's my opinion. So that's why I am. And if people don't like it and they'll try to trash me online or whatever it is, okay, that's what you have to do. But that's what we signed up for. trying to help out here. So that's going to be it for now. Thank you, everybody, for joining. Everybody, hope you have a great Sunday, and we'll see you back here tomorrow. Take care.